Okay. Our first session this morning, now that it's a little bit after 9, is ZBA decision, the ZBA decision-making process. Our speaker, Cordell Johnston, has a long history with our spring planning conference. He has practiced law in New Hampshire since 1984, first for almost 20 years at the Concord Law Firm or in Reno, and then he served as Government Affairs Counsel at the New Hampshire Municipal Association for 18 years, from 2004 to 2022. Since that time, he has maintained a solo practice limited to representing municipalities. He has written many articles and given many presentations on right-to-know law, land use regulation, town meeting, other municipal law topics. He's served as a selectman and planning board chairman in the town of Henniker, and he has been the town moderator since 2018. Let me advance the slide, and Cordell, you may now take control of the presentation.
Okay, thank you, Ken. Can you just confirm that you can hear me?
I can hear you. Yep.
Okay. I should say, as Ken knows, I had some trouble getting in this morning, and I spent about 20 minutes trying to do that, as a result of which, Ken, I didn't get to read the instructions on on how to, but I think I know how to advance the slides. Yeah, I just did it.
Excellent.
Okay.
I still see the first slide that says ZBA decision-making process. Do you have a?
How about now?
Has not advanced.
Okay.
Let me see if I controls. You should have a button that says take control.
Oh, take control?
Yeah, because it's already being shared.
Oh, there it is. Okay.
Okay.
Sorry, people.
There we go.
Okay. Now I have control. And
so there's an arrow. There you go. You got it.
Did that do it?
It did. So great.
Okay.
Thank you.
All right. Back to beginning. Again, I'm Cordell Johnston, and sorry for the technical difficulties, but I think we're on track now. So the title of this is the ZBA decision-making process. So I want to make it clear that I'm going to be talking about process and not substance. The 10:30 session, Jason Dennis will be talking about the substance of the things that the ZBA deals with, things like variances, special exceptions, equitable waivers, etc. I am talking about just the process. So let's start with talking about the purpose of the ZBA. Back about 100 years ago, when the concept of zoning first started to take off, you can imagine that some people were not happy with the idea that that towns were going to limit what they could do with their property, and there were concerns that towns would restrict their use of property so much that it would result in an unconstitutional taking. And if a town, for example, adopted a zoning ordinance that says you can never change, no person can ever change the use of their property from here on forward, that would probably be unconstitutional on its face, and the entire ordinance would be struck down by a court. But you could have an ordinance that is reasonable as applied to most people, but as applied to a particular property owner, it might be unreasonable. And so the purpose of the ZBA, the ZBA was created to act as what we refer to as a constitutional safety valve, so that even though the ordinance as a whole might be valid, as applied to a certain person, it might be invalid, and there needs to be a way to redress that problem, and that is that could lead to a whole lot of appeals to the Superior Court. So rather than clog the courts with every zoning ordinance appeal, the legislature required that if you have a zoning ordinance, you have to have a zoning board of adjustment. and RSA 673(1) says that when you adopt a zoning ordinance, you must make provisions for a ZBA. And again, the purpose of that is to avoid constitutional problems as applied to individual landowners. I emphasize this very heavily. If you remember nothing else, follow the statute, understand what the statutes say, understand, first of all, that everything that local land use boards do is governed by state statutes. And it is helpful if you know where those statutes are and can become familiar with them. If you don't follow the statutes, your decisions are gonna be reversed. So follow the statutory requirements. Also, a zoning board of adjustment is required to have its own procedural rules. Make sure you follow your rules and your zoning ordinance. Possibly, most important of all, be fair and reasonable. You're frequently dealing with contentious situations with people who are not always acting reasonably themselves, but the board must be fair and reasonable. You are, and I'm going to talk about this in a minute, you are basically acting as judges, and you have to be fair and impartial and treat everyone with respect, whether you like what they're doing or not. As I said, you're acting basically as judges. And here's a good way to look at things. Back in junior high, you learned, I hope, in your civics class that there are three branches of government. There's the legislative branch, there's the executive branch, and the judicial branch. And that's true at the federal level, that's true at the state level, and although people don't always think about it, it's also true at the town level, town and city level. At the town level, the legislative branch is the town meeting, or if you're in a city, it's the city council or board of aldermen. The executive branch at the town level is the board of selectmen, or in a city, it's the city council or board of aldermen. The ZBA, it's not exactly a court, but it serves what we call quasi-judicial function. It interprets the ordinance and regulations and applies it. But the ZBA does not have a legislative function. It does not adopt or amend the zoning ordinance. It doesn't adopt site plan or subdivision regulations. It's not an executive function. It doesn't enforce the ordinance or its own decisions. If someone is violating the ordinance or violating a ZBA decision, and someone comes to you and says, this person's violating the ordinance, it's not the ZBA's job to enforce it. It's the selectman or the the code enforcement officer or building inspector, someone within the executive branch. So it is helpful if you keep in mind that you are serving a judicial function and not a legislative or executive. Again, as I say, it's a quasi-judicial board, and in that, further to that, it acts pretty much like a court. It collects evidence, it hears testimony, it makes findings of fact, and it makes decisions by applying the law to the facts. And as in a court, when someone is appealing to the ZBA, bringing a case to the ZBA, the burden is on the party who is making that appeal to prove their case. And I just saw a question about imposing conditions. I'll try to answer questions as they come in, but I can't promise that I'll be able to do that. There was something about an example of imposing conditions. So maybe someone comes to the ZBA and they're applying for a variance because they want to have a restaurant in a zone that is not permitted. Maybe you grant the variance, but you say, subject to the condition that you not serve alcohol, or the condition that you're only open from 8 a.m. until 8 p.m., something like that. Those are just very basic examples of conditions that you might impose as part of either a variance or a special exception. It's important, again, because you are a quasi-judicial board, to guarantee to provide due process. And that is that citizens have a right to notice and the opportunity to be heard. You have an obligation to provide assistance with the process. So someone comes to the ZBA or to the land use assistant, whoever does your applications, and says, I want to apply for a variance, but I don't know how. You can't just say, well, too bad. You have to let them know what the process is to apply for a variance. You don't have to make their case for them, but you need to provide assistance to get them into the process and help them through the process. I talked about due process, and the New Hampshire statutes essentially guarantee that due process in various sections of the statutes. There's 676(7) provides for notice to abutters and other affected parties. Another statute provides for the opportunity to be heard and to appear and speak through counsel. 673(14), which I'll talk about later, ensures that the board is impartial. 674(33) requires a decision based on evidence and the facts, and 676(3), and I'll talk about this in some detail, requires that you provide a written decision in all of your cases, including specific findings of fact, and that can be very important. There are times when you need to work with other boards, and I pose the question here, when a proposal requires both ZBA and planning board approval. So for example, I'll go back to my restaurant example. I want to open a restaurant, and it's not permitted in this district, so I need to get a variance. But I'm also going to need site plan approval from the planning board. And the question arises, well, if I need approval from both, which board should I go to first? There's no legally right or wrong answer to that. You can go to either board first. I think that in that case, it's generally better to go to the ZBA first, because I may not get my variance. The planning board, the site plan approval process is usually pretty detailed and pretty intensive, and can require several weeks or even months before the planning board. And to me, it doesn't make a lot of sense to go through that planning board process and get approval, and then go to the ZBA and have the ZBA say, no, variance denied. I think it's generally better to go to the ZBA first. But again, you don't have to. I would leave that to the individual town. I would say, if that comes up in your town, talk to your local council about which way is best to go. You can have joint meetings. And again, the example I just talked about, if I need both a variance and site plan approval, the planning board and the ZBA can hold a joint meeting where the planning board considers the site plan approval and the ZBA considers the variance application, or if it's a special exception, you can do that. That can get it can get a little bit complicated to try to do that together, but on the other hand, it also can save some time. And I'm not going to go into that in detail. If the occasion comes up, you can read the statute and again talk to your town legal counsel about how to do that process. One doctrine that is very important is what we municipal lawyers refer to as the Fisher v. Dover doctrine that arose out of a case from 1980. And it's, even though that's 46 years ago, it's still good law. It says that an applicant can't keep trying the same application over and over. If I go to the ZBA to try to get a variance and the ZBA denies my variance for good reasons, they decide that it's not in the public interest, or it's going to adversely affect property values or something like that, they deny my variance. And so a year later, things have changed. Two new people have been elected to the ZBA, and I think I have a better chance now of getting a favorable ruling because the people who are on the board now like me. I go back to the board and submit exactly the same application for a variance. Fisher v. Dover says that has to be denied. I can't just because there are different people on the board, I can't come back and get a different decision. And the ZBA has to deny, should refuse to hear that case. Now, if what I'm coming back with is materially different, maybe what I was proposing originally was a 200-seat restaurant, and now I'm coming in for a cafe that will seat 15 people. That probably is materially different, and under Fisher v. Dover, the ZBA could hear that again. Or there could have been a change in the law or a change in the legal standard, and so maybe that allows me to come back. Or perhaps the ZBA denied my application because for particular reasons, and now I've come back, and in my new application, I'm addressing those reasons. I'm taking care of the problems that the ZBA identified. That would allow the case to be heard again. There was a case a couple of years ago, Transformations versus Town of Amherst, that said if the first application was denied because there was specific information missing, the board said, we can't grant this variance because you haven't provided enough information, therefore variance denied. The applicant came back and said, okay, here's the information you said you needed. In that case, the ZBA should hear it again because the applicant has provided what the ZBA has requested. So it can be sometimes a close call as to whether the second application is substantially different. And again, that's the kind of situation where you might have to talk to your attorney. One other thing about Fisher v. Dover is that the doctrine can't be used offensively. So, for example, if I got a variance 5 years ago, and then for whatever reason I never followed up on it, I never built the restaurant, I just let the property sit there, and I come back and now I decide, well, I want to go ahead with this, but the variance has expired. I come back and say, you gave me a variance 5 years ago, and therefore you can just rubber stamp it and give it to me now. Because under Fisher v. Dover, because it's the same application, the court said, no, you can't do that. You can't use it offensively. You have to submit a new application. I was just checking the chat to see whether there was anything in there. Okay. I said earlier that you have to provide assistance to applicants, and you can start by having a good application form that asks the applicant, tells them, here's what you need to show to the board. Here are the questions that need to be answered. I think most of the towns that I've dealt with already have this form prepared. and there may even be a standard form that towns are using. I'm not sure, but I will say that the ones that I see tend to look pretty much alike. So for a variance, they'll put the legal standard in there, and I think this is very helpful. Ask the applicant to state in the application, why is this variance in the public interest? Why is it consistent with the spirit of the ordinance? Why does it satisfy the hardship standard, and actually explain how the hardship standard works? I think it's very helpful to have that in there so you have a good starting point for your hearing. Okay, I said earlier that everything you do is governed by state statute, and the statutes are pretty detailed, telling you what you have to do. You get an application, whether it's for a special exception, a variance, an administrative appeal, whatever it is. The law says that you have to hold a hearing within 45 days of receipt of the application. Now, if for some reason you don't have that hearing within 45 days, can the applicant on day 46 say, ha, you didn't have the hearing and therefore I win, I get what I asked for? The Supreme Court has said no, it's not an automatic default, but you should still make every effort possible to hold that hearing within 45 days of the filing of the application. The statute also says that you have to approve or disapprove an application within 90 days of receipt of the application. It's not 90 days after the hearing, it's 90 days after the application was filed. So if someone files an application on May 9th, somewhere around August 9th, you need to count the days. That's the date by which you have to have first held a hearing within 45 days and then issued your decision. Basically 3 months. But again, don't just assume 3 months. Actually count the days, 90 days. Now, it's not unusual that you have your hearing and you say, we need more information. This application is woefully inadequate. We're not going to deny it, but we really need more information before we can make a decision. And but you're concerned about this 90-day deadline. So what you can do is tell the applicant, look, we need more information, or we're not going to be able to make a decision by the 90-day deadline. If the applicant is smart, they will say, okay, I will waive the 90-day deadline. And if they refuse to waive the 90-day deadline, and you legitimately need more information, and you don't have that information to make a decision, you can deny the application without prejudice. And without prejudice means they can come back later and reapply once they get the information. So don't panic about the 90-day deadline if the applicant hasn't provided all the information that they need, but be aware of it. And if you're not going to be able to meet the deadline, you should get the applicant to waive the deadline in writing. Notice of the hearing has to be sent to all parties by certified or verified mail, has to be published in a newspaper. Unlike planning board hearings, as I guess I'd need to check this to make sure, but I don't think planning board hearings generally need to be published in the newspaper. But a ZBA hearing, you have to publish notice in the paper, in a paper, at least 5 days before the hearing. You can, sorry, statute says who's entitled to notice. Basically, it's abutters and anyone else directly affected by the application. It's best to err on the side of providing more notice. If you're unsure whether someone is entitled to notice, definitely best to notify that person rather than to err on the side of less notice. This question comes up all the time with ZBAs, whether there is a right to a full board. ZBA is a 5-person board, and frequently, they don't have a regular meeting schedule like a planning board does. And so they're not used to meeting regularly. They get an application, and 3 of your 5 members say, well, I'm going to be out of the country the entire month of June. What do? First thing you do is you try to figure out how to get everyone to the board meeting. But the board, if you don't have, despite your best efforts, you can only get, say, 4 people or even 3 people to the board meeting. The question arises, does the applicant have a right to a decision by the full board? The Supreme Court has said no. If you have 3 or 4 members there and the board insists on going forward, then that's how it goes. A lot of boards will give you the option. They'll say, sorry, we only have 3 people available. Would you like to wait until we have 5 members available? And a reasonable applicant who's not in a great hurry will probably say, yes, I will wait until you have 5 people available, because you need 3 votes in the affirmative to get the action that you want. And I'll talk about that in a minute. So if you, let's say you start the hearing with 3 members present, only 3 members present, and you continue the hearing to a second date a few weeks in the future, and then you have all 5 members present. Can all 5 members participate at that point? And the answer is yes, they can, but they really need to read everything that's been submitted, read the minutes, and get up to speed before they participate in making a decision. Can you substitute someone after the process starts? So, for example, if you start out, you have 4 regular members present and 1 alternate for the first day of the hearing, and then at the second hearing 2 weeks later, the 5th regular member is available, so you don't need the alternate. Can that 5th regular member participate? And again, the answer is yes, if that person can get up to speed on the on everything that's happened up to that point. But again, the best thing is to try as hard as possible to get 5 members there who can participate throughout the entire process. I did see a question. Okay, in the chat, what if the board did not meet the 90-day requirement and the applicant will not waive? Again, if the board didn't meet the requirement because they needed more information and the applicant refuses to waive it, then you deny it without prejudice. If the board doesn't meet the requirement just because they're lazy, then I think you have a problem, and the applicant says, no, I'm not going to waive it. I'm entitled to a decision within 90 days, and the board just refuses to do it. Then you have a problem. Who is ultimately responsible for having a current and correct abutters list? I believe, and this is a level of detail that I don't usually get into, but I think that the applicant is responsible for providing a list of all of the abutters. If anyone who deals with that process regularly knows a better answer to that, let me know, but I believe it is up to the applicant. So let's talk about the hearing itself. At the hearing, board members may ask questions and should. It's very important. I hate to see a board just sit there and listen to the applicant and say nothing. Um, uh, the applicant is presenting his or her case. People who may oppose the application are presenting their cases. Not everyone presenting a case in a hearing is all that articulate. They may not cover all the issues, and the board members really should hold their feet to the fire and make sure that they do cover all of the issues. So ask questions. I mean, don't be rude and interrupt every 5 seconds, but when the applicant has made his or her case, then say, okay, you didn't address this, you didn't address this, you didn't address this. Can you please answer these questions? And don't sit there and think this is a stupid question. Everyone else knows the answer to this and I don't. If you don't know if you didn't get an answer to a question, you're probably not the only one. So more questions are always better than fewer. The question of alternates participating comes up frequently. If one of the regular members is not present and I'm the alternate designated to sit in that person's place, of course I'm participating fully. But what if the entire board, all the regular members are present, and you also have 3 alternates present? So you don't need them to make the decision because you have all the regular members. Can the alternates nevertheless participate in the hearing? Can they sit at the table and ask questions? The answer is yes, if the board's rules of procedure allow for that. You should check your rules. You are required to have rules of procedure. Check your rules and see what they say about alternates participating in the hearing. Disqualified members, and I'm going to talk about disqualification in a few minutes. If you are disqualified or in other words, recused because of some kind of conflict, you should go sit in the audience and you can participate. If you're disqualified because you're an abutter, you can speak as an abutter. You can't participate as a board member. But you have every right to participate as an abutter, to speak as an abutter or as a member of the public. The statute says that the board must hear all parties and may hear such other persons as it deems appropriate. I rarely see a board deny someone the opportunity to speak. I mean, unless it's something where you have 100 people there and a lot of them have nothing really to do with the application. They just want to be heard. But most of the time, it's not a problem to let anyone speak who wants to speak. I said I would talk about disqualification, more often referred to as recusal. This is very important. The statute says, 673:14 says, a member is disqualified if he or she has a direct personal or pecuniary interest, or would be disqualified to act as a juror in the same matter. So if this were a case in court, would you be disqualified to serve on a jury? Now, there are obvious cases. If you are the applicant, obviously you can't participate as a board member. If you're an abutter, you can't participate as a board member. Just an interesting war story. I had a case about 8 months ago where it was an appeal of a decision appeal of an enforcement decision by the Board of Selectmen. They appealed to the ZBA. So the 5-member ZBA included the applicant. The chairman of the ZBA was a direct abutter. A third person on the board was one of the selectmen who had signed the enforcement order. So, so there are only 2 regular members of the ZBA who were not automatically disqualified. Sticky situation. And the board didn't have very many alternates, as I recall. They were able to cobble together, I think, 2 regular members and 2 alternates to sit and decide this case. But it can be difficult when you have members who are disqualified. So as I said, obvious cases are if you're the applicant, you're an abutter, you're married to the applicant, an immediate family member, you probably need to recuse yourself. Other situations, and I've put these in red for a reason, if a member of the board has formed an opinion or is prejudiced to any degree regarding the case, you have to recuse yourself. And this requires an examination of your conscience. Am I determined to kill this variance, or am I determined to support this variance because I like the applicant or because I hate the applicant or whatever? It's not simply a question, have I expressed an opinion in public? The question is, am I biased? And if you are biased, if you go in with an opinion and you're determined to stick to that opinion no matter what, you should not be sitting on that case. I had a case a couple of years ago where I was advising a ZBA, and as I talked to the chair of the ZBA over time, it became pretty clear that he was determined. He had done all kinds of research about the applicant and was telling me about all the things, all the misrepresentations the applicant was making. It became pretty clear to me that he was biased and he shouldn't be sitting. I made the mistake of not saying anything. I should have told him, you have to disqualify yourself. I didn't. We went forward. He led the decision that denied the request for a variance. I was surprised that the applicant didn't appeal because he was very clearly biased and should not have been participating. If you find yourself doing background research on the applicant to find reasons to deny the application, as I said, you have to examine your own conscience. But if you have that strong an opinion, you need to recuse yourself. Now, you could think going in, this seems like a bad idea. But if you're willing to hear the evidence and be persuaded, then I don't think you need to recuse yourself. You don't have to be completely devoid of thoughts, but you have to be willing to be persuaded one way or the other. I'm looking in the chat briefly. An applicant waives the 90-day requirement. The ZBA continues the hearing. How many months should you let the applicant continue to ask for postponements? I guess that's a judgment call. I'd be inclined to give them a fair amount of leeway. If they are legitimately trying to gather the information, if it becomes clear after a while that they're stalling, then I would say, look, we gave you 6 months and you didn't do it. We'll deny it without prejudice again, because you haven't provided the information. We'll deny it without prejudice and you can come back later. Someone saying an abutter list can be generated in the town's GIS map system. Can the board ask questions of abutters or public comment during the hearing? Yes. I would ask questions of the abutters when the abutters are speaking. I wouldn't, if the applicant's presenting his case, I wouldn't say to the abutters, well, what do you think about that? I'd wait until they speak. Yeah, so anyone who's speaking, you can ask them questions. They don't have to answer it, but you can certainly ask. Someone says you didn't address the question if agreeing to a continuance makes the 90-day not required. If someone agrees to continue it, you have to get them to agree to waive the 90 days. So if you have your hearing within 30 days, and then your second hearing is 20 days later, now you're at 50, you're okay. But if you want to keep it going past 90 days, you're going to have to get a waiver. I'm going to go back to my presentation because I need to get through it, but I will come back to the chat if I can. Back to the disqualification issue. The statute says that any board member can ask the board to vote on whether someone should be disqualified. So if I'm on the board, I could ask the board to vote on whether I should be disqualified, or I can ask the board to vote on whether the person to my left should be disqualified. And the board takes a vote, but curiously, the vote is non-binding. So it's advisory. Yeah, we think you're disqualified, but I don't have to pay attention to that. My position has always been, if I ask the board to vote on whether I should disqualify myself and they unanimously vote, yes, you should disqualify yourself, then I better do it. Because if everyone else thinks that I'm biased and not impartial, then there's probably a good reason for that. Yeah, you should understand that participation by just one member who should have been recused can result in reversal of the decision, even if it's a unanimous decision. I'm one person who opposes this application, and the entire board agrees. It doesn't matter whether I was a deciding vote. Just the fact that I participated could cause the decision to be reversed. So be very conscientious about that. Back to discussion of the public hearing, I talked about continuing the hearing to another day. That happens frequently, especially with complicated or controversial applications. You don't need to provide new notice, but if you're going to continue it, you start the hearing tonight and you're continuing it to 2 weeks from tonight, you must announce tonight, okay, we are continuing the hearing to May, whatever that would be, May 23rd at 7 p.m. at the town hall, date, time, and place. And if you do that, you don't have to provide the other statutory notice. If you are continuing the hearing, you should not have any contact between the parties and the board members, or any discussion among board members about the hearing in the interim, because you still have a hearing going and it has to be a public hearing. So all discussion has to take place in public. Another thing is, don't close the hearing too soon. Make sure you get all of the information that you need during the hearing. Frequently, I've seen a board say, okay, we're done, close the hearing, and then they go into deliberation, and then they realize they didn't get some information that they needed. They reopen the public hearing. The problem with that is, and usually you get away with it, but the concern is you reopen the public hearing. Some people may have left because you said the hearing is closed. Now you're reopening it, and the people have already left, and they're not able to participate in the continuation of the public hearing. So try very hard to get all of your questions answered before you close the hearing. Frequently, you will need to obtain legal advice from your town attorney or whoever the attorney who's representing the board. You can do this at any time. you can, and you're all familiar, I hope, with the right to know law that says basically you have to do everything in public. One thing you don't have to do in public is meet with your attorney. There is a blanket exemption, and a meeting with your attorney is not, it's not a non-public session under the right to know law, which requires a very specific process. It's considered not a meeting at all. So if you're meeting with your attorney, you just go into a back room and meet with them. There's no motion, there's no minutes required, nothing. It's just, we generally refer to it as a non-meeting. And again, if you have questions, legal questions, from reviewing the application before you start the hearing process, you meet with your attorney then. If you get into the hearing and questions come up, and if your attorney happens to be there or is available by phone, you can take a recess and meet then and have your questions answered. Of course, I'm an attorney and I get paid to provide legal advice. But apart from getting paid, I do recommend, if there are questions, that you use make liberal use of attorney to get the questions answered correctly, to avoid making a mistake. There is, if your attorney has written a letter to the board, that's not a consultation with legal counsel. That is something that you can review that letter in non-public session. If the lawyer is not physically present, or not present by phone, you can't have this so-called non-meeting, but you can go into a non-public session. And I realize it's a fine distinction, and it may be a little confusing, but you can have a non-public session to discuss written advice from your attorney. But usually the better option is just having that meeting either face-to-face or by telephone with the attorney. So you've had your public hearing and you need to make your decision. And again, I hope that you've had all of your questions answered. There's nothing else, no more information that you need to make a decision. You just need to now make a decision. Again, if you need to get legal advice, do that. And then you deliberate, and you must deliberate in public. I remember way back before I was even practicing municipal law, attending a hearing of a planning board where they had their hearing and then they said, okay, we're going to adjourn to deliberate. And they went into a back room and made their decision. You can't do that. Do not do that. You must deliberate in public. And as uncomfortable as that may be sometimes, it has to be done in public. Now, you might close your hearing, say it's a contentious hearing or it's complicated and it takes 4 hours, and you started your public hearing at 7 o'clock, it's 11 p.m., and you're all practically incoherent because it's so late. You don't have to deliberate then. You can continue, you can say, we're going to take this up at our next meeting. Now, you've closed the hearing. So what you're doing after that, it's still part of a meeting, but it's not a public hearing. So it doesn't require legal notice. You don't have to state then the date, time, and place of your next meeting. And once you determine when that next meeting is, you don't have to send notice to the applicant and the abutters, because again, it's not a public hearing, it's just a meeting. However, it's a good idea, I think, to let at least the applicant and any interested abutters know, either just by email, if you can, if you can, when you're actually going to do the deliberation. I'm going to go back to the chat and see if I can answer a few questions. What happens if an entire board has a negative past experience with an applicant? Try to get past it. And this is very important. Understand that decisions must be made based on the application, not the applicant. The applicant is a jerk is not a permissible reason for denying an application. The applicant wants to do something that would be really bad, would be against the public interest, would violate the ordinance, would, pollute the groundwater, etc. Those are good reasons, but just we had a bad experience with the applicant. Try to get past that. If you can't, if you, again, examine your conscience and say, there's no way I can support what he wants to do because I hate him, then you need to recuse yourself. But try not to do that. And another thing, you can't deny an application because this has come up. Well, we know the applicant is delinquent on his property taxes on another property, or the applicant has violated environmental laws on another property. That is not relevant. What is relevant is the application that you have before you. Try very hard to separate the applicant from the application itself. Okay, I'm going to try not to jump around so much. Back to deliberating. It's only among the board members. You should not be entertaining any comments from the public once you've closed the public hearing and begun deliberations. Should not ask questions of the parties. If you really have to ask questions, then reopen the public hearing. But again, try very hard to get all your questions answered before you close the hearing part of the meeting. Minutes are crucial. Especially if you have a case that there's any chance that someone is going to appeal the decision to the court or to the Housing Appeals Board. And I'll talk about this a little more later, but it is very important to have thorough and accurate minutes of what the applicant said, what the abutters said, any experts who testified, what they said, and what the board members said. So try to hire yourself a good minute taker who understands what's going on. While you're in deliberations, start by saying, well, okay, what is it that the applicant is looking for? The applicant wants a variance. Okay, so they have to satisfy these 5 criteria. Go through each of them and figure out, do they satisfy them? As I say here, focus on the law, on the facts, not on how you feel. You think, oh, I just don't like this. That's not a basis for a decision. The decision should be based on the law and the facts. Expert evidence is frequently offered in hearings, and you should listen to expert testimony. It might be testimony of an environmental engineer, an architect, a real estate appraiser, and frequently you'll hear competing experts. One appraiser says this will increase property values. Another appraiser says this will decrease property values. You can weigh them and decide which one you think is more credible. You have considerable discretion to do that. However, if you have one expert who says something and there's no expert on the other side, you can't just reject that one expert's opinion out of hand. You can't just say, we're not going to listen to that. You have to have a credible reason for rejecting that opinion. You think the person is not qualified, the way he's analyzed things doesn't make sense, and you need to identify why we're rejecting that expert opinion. And just kind of general articles, general information about a subject usually is not going to be sufficient to reject a qualified expert's opinion. So be very careful about that. But you don't have to rely just on experts. And in most cases, that's not what most of the testimony is. In most cases, it's coming from the abutter, the applicant, the abutters, and others, including board members. Board members can rely on their own knowledge. You're familiar with this neighborhood, so you have an idea what kind of impact this proposal will have on the neighborhood. You can base your decisions on that, but not if there's uncontroverted expert testimony to the contrary. So, this expert says this is definitely going to have an adverse effect on property values, and here's my study, and here's how it all works. And it's competent testimony. You can't just say, well, I disagree. I think this is going to help property values. You can't do that. But if there is no expert testimony and you're relying on just the information provided by the applicant and the abutters, and again, you as a board member have knowledge, you can rely in part on that knowledge to make your decision. So you've had your hearing, you've had your deliberations. Now you need to make a motion. You should have rules of procedure that talk about making, seconding, and voting on motions. I emphasize here, do not try to follow Robert's Rules of Order. There's almost no one in the world who understands Robert's Rules of Order. They are not appropriate for a 5-person ZBA. I asked the question, may a member draft a motion ahead of time? Yeah, you can. Although if you show up at the beginning of the hearing with a motion to deny the variance, that kind of suggests that maybe you're biased and you shouldn't be offering that motion. But if if the hearing's been going on for a while, and you come to a conclusion during the course of the hearing, yeah, you can draft a motion. But do not circulate it, because you should not be discussing with members outside of the public hearing. I say, to avoid confusion, allow only one motion before the board at a time. You don't want to get into a situation where one member moves to approve the application and then the next member immediately moves to deny the application. That just leads to confusion. Someone makes a motion, make sure you act on that motion before you move on to something else. As I say, if you're drafting the motion, start with what the applicant has asked for, and basically you're going to approve it or deny it, or you may approve it with conditions. And different board members may have different ideas about what conditions should go in there, and so you may end up amending the motion once or twice or 3 times to add or delete conditions. Once you come up with a motion, make sure the text of that motion is in the minutes. Make sure the person taking the minutes has that motion in writing so it doesn't get confused or distorted. And if it's being recorded, make sure the motion is read out loud and require an audible vote from every member. I'm not going to talk too much about conditions of approval. But there are basically 2 kinds. Conditions precedent, those are conditions that have to be fulfilled before approval is final. Those more typically used by planning boards in site plan or subdivision review, but there could be such conditions for ZBA approval. Conditions subsequent, I mentioned before, we will approve the variance subject to the condition that you're only open from 8 a.m. to 8 p.m. or something like that. That becomes part of the approval. The variance is approved, but that condition is part of it, and that condition stays as part of it. As I say here, the condition has to relate to the use of the land, not the person using it. So you can't put in a condition that says we'll grant this special exception or this variance only so long as Mr. Smith continues to own the property. And if he sells it, then the special exception goes away. You can't do that. It has to relate to the use of the land, and it runs with the land. Once you grant that variance, and this is something to keep in mind, once you grant that variance or special exception, that attaches to the land forever. So don't just think somehow it's going to go away when the current owner dies or sells it. That doesn't happen, as I say on this slide. There are a few exceptions to that. I'm not going to get into that because I'm kind of running short on time here. The statute says that you must have at least 3 concurring votes to take any action, regardless of how many members are seated. And this is why you might give, if only 3 members of the board show up, you might give the applicant the option of waiting until there's a full board, because it's easier to get 3 votes out of 5 than 3 votes out of 3, obviously. Then the question says, well, what if you don't get 3 votes in favor? I make a motion to approve the variance, and that motion fails on a 2-2 vote. What happens next? Someone else, say another member, says, okay, I move to deny the variance, and that fails on a 2-2 vote. What happens? My view is that if you can't get 3 votes to approve the application is denied, but not all lawyers agree with that. As I say here, ideally, your rules of procedure should answer that question. Voting on variances, I'm not going to talk about that because Jason, I assume, will talk about that in some detail in the next session. Back to the minutes. As I said before, they are critical. A decision may be reversed on appeal if the minutes don't show sufficient evidence to support the board's decision. I had a case not long ago where a board denied a variance, and one of the criteria for a variance is the applicant has to show that that the proposal will not have a negative impact on property values. So we had this hearing. There was one abutter who showed up and he said, I believe this will decrease the value of my property. And there was some other stuff, but that was important. And that was just that one sentence. I believe this will decrease the value of my property. The variance was denied in part because of that. The applicant appealed. It went to the Superior Court, and the Superior Court said, well, the abutter testified that it would decrease the value of his property. Therefore, there was evidence from which the board could make that decision. Now, if that statement had not been in the minutes, the court might well have said, there was no evidence on this, and therefore the ZBA could not have made that decision. And I've had so many cases where there were just 1 or 2 things that were in the minutes that supported the decision. And if they had not been in there, the decision might well have been reversed. So, but for lack of supporting, sufficient supporting evidence for that decision. So that is why I say it's very important to summarize the important points that were made by the applicant, that were made by the abutters, the points that were made by the board members explaining why they decided something. I have read cases where a decision was reversed because the board didn't explain, or there was no explanation by the board in the minutes of why they decided the way they did. Extremely important. RSA 676(3) says you must provide a written notice of decision. It can't just be a record in the minutes. And that written notice is important because it provides guidance for the future as to what is permitted, and guidance to enforcement officials as to what is permitted. The notice of decision is this gets a little difficult because it's supposed to be made available within 5 days. It's impossible. It's not impossible. It's very difficult to write a good notice of decision at midnight after you've had a 5-hour hearing and you've made a decision, unless the decision is just denied because there was clear evidence that this would negatively affect the abutter's property value. But in most cases, you need a pretty thorough decision that explains why you made the decision and cites specific findings of fact. The statute says the decision must include specific findings of fact that support the decision. What I encourage boards that I represent to do is they take their vote after they've had their hearing and deliberated, and then work with me as their attorney to write up the notice of decision and incorporate the necessary findings of fact into that decision. And you don't have to do that the night of the decision. You have 5 business days to do that. And take the time that you need to do that and do it done right. I think the board ideally votes to designate the chair or someone, but usually the chair, to work with legal counsel to write the findings of fact in the notice of decision. And maybe you don't need to, I'm not trying to make money here. Maybe you don't need to work with your legal counsel. Maybe the chair is competent to do it without legal consultation, but take the time to do it right and make sure that the necessary findings of fact are in that decision. As I say, it has to be done within 5 days, 5 business days. If not, it's not going to be the end of the world if you don't get it done within 5 business days, but you really ought to try to do that. It's not going to make your decision invalid. It is technically a violation of the right to know law, but it's not going to be the end of the world, but try very hard to get it done within 5 business days, which is basically 1 week. Motions for rehearing. You make a decision, someone doesn't like it, they cannot immediately appeal to the Superior Court. If the applicant doesn't like your decision, or an abutter doesn't like your decision, before they can appeal, they have to file a motion with the ZBA, a motion for rehearing. That can be filed by any party, including an abutter. It can also be filed by the select board, which is not unusual. I've had more than one case where the select board appealed a decision by the ZBA. It gets a little uncomfortable, but it happens. The motion has to state every reason that the decision was unlawful or reasonable. So they filed that. Again, before they can appeal to the court, they have to request a rehearing by the ZBA. So if you get a motion for rehearing, you have to grant or deny that motion within 30 days. What you do is you hold a public meeting, not a new hearing, just a meeting. And you're not required legally to give notice of this, although, again, as a courtesy, it's a good idea to notify the parties that you're going to discuss this motion for rehearing at a meeting on a particular day. I advise boards that their decision should just be on the motion for rehearing, one word, granted or denied, not go into the reasons for it. Why would you grant a rehearing? If you are convinced that you made a mistake in your decision, you can grant a rehearing. If there's new evidence that emerges that was not available at the time of the original hearing, something has changed and there's new evidence, you might grant a rehearing, not just because the applicant could have provided expert testimony at the first hearing but failed to do so, and now he has someone who's willing to testify. That's not a good reason for a rehearing. But if there's actual new evidence, new developments, you might grant a rehearing. If you do grant a rehearing, the case starts all over. You're back to square one. You schedule a hearing, you send new notices, everyone can provide information. It's a whole new ball game, and you're not even limited to the issues that were originally identified. It's just you start all over. Once you either you deny the rehearing or you hold a rehearing and you make a decision one way or another, somebody still doesn't like it, they appeal to the Superior Court. In some cases, they can appeal to the Housing Appeals Board. I'm not going to get into the process for that because most of that isn't your issue. It's up to the person filing the appeal. But the one very important thing is that you will need to compile the record of your proceedings, because on the appeal to the Superior Court or the Housing Appeals Board, the court's decision is going to be based strictly on the evidence that's in the record. Sometimes there's a motion to expand the record, but mostly it's just what was before the ZBA when it made its decision. So you're going to include the application, the notices, everyone who testified, any documents that were submitted in support of or in opposition to the application, the minutes of the hearing, the decision, the notice of the decision, everything, any correspondence that occurred. And you need to, if you have a clerk, or if you don't have a clerk, your chair, your land use assistant, whoever, should be working with your legal counsel to compile that record that needs to be certified to the court or to the Housing Appeals Board when that case gets appealed. And it's very important to understand that and make sure that that record is complete. I have a few more slides here, but I try to be strict about ending on time, and I believe I'm supposed to end right now. So I know there's some questions in the chat, but I think we have a Q&A session this afternoon, and maybe we can answer some of those then. So I'm going to turn it back over to Ken, I think.
Great. Thank you very much, Cordell. I was going to mention the same thing about the Q&A session coming this afternoon after our other two sessions. I was just about to put a message in the chat. I'm going to probably do it each time, but please remember to leave any comments on the feedback form that's available. Let me just put that in right now. Okay. We take your comments seriously, and we always are looking for ways to improve how we prepare, how we do our conferences.